I sat in there for 7 days. 7 days in the jailhouse, like a criminal.
And look, you probably think your HOA is a government. You think they've got the legal power to fine you into bankruptcy just because your trash can is 3 inches too far to the left. Well, that is a lie. They send you nasty letters because your grass is the wrong shade of green. They tell you what color you can paint your front door, how long your guests can stay, and whether or not you're allowed to park your own truck in your own driveway. They act like a mini dictatorship with zero accountability and a budget primarily spent on harassing you. I'm going to show you the 5 ways to flip the script. We're going to look at the specific legal traps backed by actual court cases that turn the hunter into the hunted. And I'm going to show you how to make them regret the day they decided to put your address on their target list. And we're going to do it without breaking a single rule. Because the best revenge isn't petty. The best revenge is compliance, weaponized. So let's start with move number 1. And we call this the Turtle Rock maneuver. Here's the scenario. You get a fine. Maybe it's $50, maybe it's $500. The letter says you violated Rule 4, Section B, subsection we don't like you. So your instinct is to argue about the rule. But Karen, my trash can wasn't out that long. Stop. Do not argue the facts. Argue the process. In a famous case called Turtle Rock 3 HOA versus Fisher, an Arizona court looked at an HOA that was handing out fines like candy at a parade, and the court asked one simple question: where is the fee schedule? See, an HOA cannot just make up numbers. They cannot wake up on a Tuesday, decide they are angry, and charge you $100. They must have a published board-approved fine schedule that was distributed to all members before the violation occurred. If they didn't publish it, or, and this is my favorite part, if they didn't record the meeting minutes where they voted to approve that specific schedule, the fine is void. In fact, the court didn't just void the fine. They voided the entire authority of the board to collect. It doesn't matter if you left your trash can out for a month. It doesn't matter if you painted your house neon pink. If they didn't show their work, they cannot collect the money. So here's your move. Do not write a letter explaining why you did what you did. Write a letter simply saying, please provide a copy of the official fine schedule and the meeting minutes where this schedule was adopted by the board, as required by state law. Watch them panic. Watch them scramble to find a document that likely doesn't exist. You win on a technicality. And in the legal world, a technicality is just as good as a knockout.
They discredit me. They tell me, basically go away. This is how it is. If you don't like it, move out.
But here is the secret they do not want you to know. Most HOA boards are not legal experts. They are not government officials. They are usually a group of bored amateurs playing with legal dynamite. And right now, they are holding a lit fuse. If you have ever opened your mailbox, seen that envelope with the HOA logo, and felt that specific mix of rage and anxiety, you're not alone. But you are playing the game wrong. You're playing defense. You are trying to explain yourself. You are asking for mercy. Well, today, we're switching to active offense.
Furious community members say the meeting escalated when the HOA board told residents their monthly fee would increase to $350 a month.
Move number 2 is for when the HOA decides to get creative. We call this scope check. You see, HOA boards love to improvise. They sit around the table, drunk on the power of a $200 annual budget, and they decide to ban something new. No holiday decorations before December 15th. No political signs. No pickup trucks parked on the street. In a case called Tyranny versus Belmont Glen, the Virginia Supreme Court slapped an HOA so hard it probably still hurts when it rains. The HOA tried to enforce strict rules about seasonal decorations. They thought they were protecting the neighborhood. The court thought they were overstepping their bounds. The ruling was simple. An HOA cannot enforce a rule that isn't explicitly granted in the covenants, conditions, and restrictions, the CC&Rs. They cannot just adopt a guideline that restricts your property rights unless the original deed says they can. So if you get a violation for something that feels made up, go to the CC&Rs, search the document. If the power to regulate Christmas lights isn't in there, they can't enforce it. They are acting outside their scope of authority. And when an HOA acts outside its scope, they aren't just wrong, they're liable. They're spending community money to enforce a rule they don't have the power to do. Remind them of that. Ask them to cite the specific article and section of the CC&Rs that grants them this power. Usually, they can't. Now, move number 3, and this is the big one. This is the pivot point. You see, moves 1 and 2 require you to write letters. They require you to read the documents. They require you to engage with Karen and Bob on the board. And let's be honest, Karen ignores letters from you. She reads your email, rolls her eyes, and adds a late fee just for fun. Why? Because she knows you aren't going to sue. She knows a real estate attorney costs $450 an hour. She knows a retainer is $5,000. She's banking on the fact that you will run out of money before she runs out of patience. It's a game of financial chicken, and the HOA has a bigger bank account than you do. But what if you could change the math? What if you could drop a nuclear weapon on their desk for the cost of a tank of gas? This is the loophole the rich use. They don't fight Karen, they outsource Karen. Because when an HOA receives a letter on law firm letterhead, when they see cease and desist written by a licensed attorney, they stop laughing. They stop rolling their eyes. They call their attorney. And their attorney tells them, this guy is serious. This is going to cost us $10,000 to fight. Drop it. But you don't have $5,000 for a retainer. And that is why you need this tool. If you go to bullyproofmylife.com, you can essentially put a legal force field around your house for less than the cost of Netflix. We're talking about a service where you tap a button on your phone, you upload the violation letter, and a real lawyer in your state reviews it. And if you've got a case, they send the letter. Suddenly, the bully isn't fighting you. They're fighting your attorney. They are fighting a skyscraper full of attorneys who argue for a living. You have flipped the power dynamic. You have sent a signal that you are not the prey. You are the predator. You need to have this in place, though, before the fight starts. So go to bullyproofmylife.com and do not wait until you're being sued. Get the weapon in your holster now. Have it at the ready, always. Because nothing makes an HOA regret messing with you faster than realizing you've got better lawyers than they do. All right, let's say they ignore the lawyer. Well, it's time for move number 4, the nuclear option. You see, most HOA board members think they are protected. They think, I'm a volunteer. You can't sue me personally. The HOA's got insurance. Wrong. There is one specific area of law where the corporate veil is pierced, where the insurance company says, hey, you're on your own, pal. It is the Fair Housing Act. Under HUD regulations, if an HOA board selects you for selective enforcement based on a protected class, or if they create a hostile environment through harassment, the board members can be held personally liable. That means their house is on the line, their retirement account, their kids' college fund. If they're fining you for a trash can, but they ignore the board president's trash can, that is selective enforcement. If they're targeting you because you've got kids, or because of your religion, or just because they don't like you, that can be construed as harassment under the FHA. You don't just file a complaint with the HOA, you file a complaint with HUD. That's the feds. When a federal investigator calls the board president at home and asks about personal liability, the color drains from their face. The power trip ends the moment they realize they could lose their own equity trying to steal yours. And I'm not telling you to file false claims, but I am telling you that if they are bullying you, it is often more than just annoying. It is illegal. And reminding them of their personal liability is a very effective way to make them find a new hobby. And finally, move number 5, the ombudsman. Some states, like Nevada, Florida, and Colorado, have realized that HOAs are out of control. So they created a referee, an ombudsman. This is a government office dedicated to slapping HOAs. Yeah, this thing exists. You can file a formal complaint, often for free or a small filing fee, and the state will open an investigation. They will demand the records. They will demand the financials. They will force the HOA into mediation. HOAs hate this because it creates a public record of their incompetence. It forces them to hire their lawyer to defend against the state. It drains their budget and makes the other homeowners ask, why are we spending $5,000 defending the board president's ego? It turns the neighborhood against them. Now, you've got the tools to handle the amateurs, but here's the reality check. Defeating the HOA is just winning a battle. You are still losing the war. You see, while you were distracted fighting over a trash can, The county assessor just legally stole $3,000 from you in property taxes, and you didn't even notice. You need to see the full picture. You need to know exactly where you are bleeding money. And I expose exactly how that theft happens and the audit tool that catches it in this video right here. We're gonna run a full diagnostic on your entire household economy to find these leaks and generate your personal defense score. So click right here and let's see if your home is actually secure.